You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, sir.
An officer is in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up.
This courtroom session is absolute chaos from start to finish. We've got interference with police during a capital murder warrant, a commercial driver accused of intentionally hitting another vehicle, a defendant missing 19 alcohol tests, a scram device allegedly tampered with for 25 hours, and a man on lifetime probation for armed robbery now facing an aggravated assault with a deadly weapon charge. This isn't just one case. It's a cascade of bond violations, credibility battles, and a judge who makes it crystal clear public safety comes first. Watch closely because today you're going to see how bond decisions are really made and how quickly freedom can disappear when the court believes you're a risk.
On the officer's perimeter, got out of their motor vehicle and began walking to the residence where the murder suspect was. The officer supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there.
Stop.
Oh, sorry, sir.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant.
Okay.
He stopped. He refused to just stop going towards the residence. Your Honor.
Did it serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It's not said. I have no further facts that show if the warrant was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence, and that's when this incident.
Read it again, if you don't mind.
Yes, Your Honor. The law enforcement officer in Squad 5 of the Houston Police Department's gang division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant was once again ignored the officers. The law enforcement officer grabbed the defendant and made him bounce and the ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what, so I was originally reading the summary and I'm going straight from the gems down, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that there was that the suspect, that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor.
I find no problem causing your case. Just be careful, man. When you get into a pissing match with
I understand.
who's going to win?
They are. I understand.
No.
Yes, sir.
Hand.
All right. Sit down.
Please.
For a bond today, and so
In custody?
she is, yes, Your Honor, and she has one pending felony, but she's out on a bond for that one already. She just has no bond set in this case.
I see bond sets. I see the FSGI is at 1,000. Yeah.
Okay. I talked
It must have
to,
just gotten said. I don't know.
okay, is it a PR bond?
No. It's a
Okay.
shirt.
Okay, then if we could review it today, is that possible?
Absolutely. Do you
Okay.
mind, Deputy Etchigoin, do you need a translator?
No.
Do you mind me bringing up Miss Gill? All right. Good morning, Miss Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Oh, well, hold on. Yeah, the right to remain silent. Anything you say can or will be used against you. Okay, good.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Drive, Wallaceville Road in Harris County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So are
complainant,
you telling me that now it was intentional?
the complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck the vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt. Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
In this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because allegedly hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor. May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. Has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that the felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping me. I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. They're a small farm animal. I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes. Really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right? I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
Terminated from employment too.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case
sir. Yes, sir.
and just, all right. Come on. Justin. Come up, Mr. Jones.
Mr. Nealon is in Cancun until Monday next week, Judge, so he's not available this morning.
I
So I'm kind
understand.
of filling in. I have had a chance to look at this violation report regarding Miss Blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
Says 19, Your Honor. Within that 7 but Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm
hear-
sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize, sir. Can I please speak on the breathalyzer?
No.
Just
You
told me
know
last
what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please.
No.
And but to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate, for alcohol.
I go to sleep early, man.
Test. And he is blowing outside the window, so we don't know what he's doing.
My God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
They just told me about this last week in pre-trial over there, and they said that I
Look
had
at
the 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor, I will do anything. I'll even go on that drug, Anklemon. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor, it's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I would wake up, and they told me this just last week, Your Honor. I swear to God, I swear on everything I love.
You know
Please give me a chance, Your Honor.
testing schedule is, and I've given you one
I started
pass
doing the wrong-
after the other. He goes with you. No,
Oh my God.
Your Honor, may we discuss setting a new bond for
of course.
Oh my gosh. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera,
Yes, sir.
then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay. Great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't. But, fine. Because
Email from,
if anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also,
You went the day before court.
that's- And I also went before.
Judge, she's been going. She's been going before, even the last court date, and we, you know,
Prove it.
I can text you.
In this life, you're only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I have an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, you know, attempt to go to the class. So she's been going. She did already take a test, and this is one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
I'm trying to text you.
Texting who?
The instructor. Like, what I'm supposed to show you? Because I don't have no proof. Like, I don't have nothing.
Tell me what have you done?
I went to the class.
Okay. Which class did you go
The
to?
GED resource.
Okay. And what, because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining how everything's going to go, and I was going to finish everything else Wednesday when I was going to go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number, because I'd like to call them right now.
I have a number for you, Judge. Charles Jackson.
Mr. Jackson? Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. So, I've got him. Okay, Mr. Jackson?
This moment is critical. The judge isn't just reacting to the charge. She's reacting to demeanor. In bond hearings, attitude absolutely matters. Courts evaluate two main factors: risk of flight and danger to the public. Here, the judge clearly believes reckless driving combined with prior felony probation creates a pattern. When someone is already on probation for assault of a peace officer and injury to a child, and then allegedly backs into another vehicle intentionally, that signals escalation. The defense brings up mental health, lack of medication, and hardship. Those are mitigation factors. But mitigation doesn't override public safety. And here's the bigger question for you. Should bond decisions weigh emotional frustration and mental health more heavily? Or does repeated risky behavior outweigh personal struggle? That tension is exactly what you're watching unfold in real time.
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a probation where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED content. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
How long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question, depends on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I've worked with people that have gotten the GED in 3 weeks. I've worked with people that got the GED in 2 years.
I can't do 3 years. That's too much.
Well,
I know, I'm kidding.
No, I understand that.
She's been faithfully attending though? Yay or nay? Okay, great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay, so I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got, like what he's saying, if you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You take
Okay.
care.
You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. Good job. What's the last name? Oh, I'll call you if he shows. Why are you here?
Tengo corte hoy. I have court today.
No kidding.
De veras.
You don't say. ¿Por qué también estás aquí, señor Lazo?
Nomás porque tengo corte. Just because I have court.
You have a bond violation.
Violación de su fianza.
They are telling me that you are tampering with your scram device. Specifically, at 1 in the morning on
de la mañana,
October 15th.
el 15 de
Judge,
octubre.
with that,
Pues con
there's not very much
eso no hay
information
mucha
listed on that
información.
PR. I looked further into it. The tamper lasted a duration of 25 hours and
Duró
51
25 horas y
minutes,
51
and alcohol was
minutos y
detected,
alcohol fue
but could not
detectado,
be
pero no
confirmed
pudo ser
on that
confirmado.
tamper as well.
Ese caso de manipulación también.
What they're telling me is that you tampered with the device for about 25 hours
5 horas.
and alcohol was detected during that time.
Yo ni siquiera he movido el aparato y alcohol no he tomado nada.
I haven't even moved
No
the
drink
device and
No, they're
I
telling me.
didn't drink any alcohol. Eso no es lo que me está indicando.
Sí, pero yo no he tomado nada,
I
nada que
haven't
he
drank
tomado,
anything.
nada.
Nothing.
Y esto ni,
They're telling me.
Eso
ni
no
lo
es
he
lo que me están
movido.
diciendo. I haven't
No lo he
moved it.
movido
I
nada.
haven't moved it or anything.
That's not what they're telling me.
Eso no es lo que ellos me están
Pues
indicando.
no sé cómo, pero si yo no lo he
I don't know how I
movido.
haven't moved it.
Y ni he tomado
I
nada,
haven't
nada,
drank or anything.
nada.
I unfortunately don't know
Nuevamente,
how
no sé
you tamper
cómo
with the
fue
device, Mr. Lazo.
manipulado.
But from what I understand,
Pero por lo que
I want you
entiendo,
to listen.
quiero que escuche.
You have somehow
De alguna
tampered
manera
with the device.
ha
The
interferido
device is supposed to maintain a constant contact with your skin.
con su piel.
And the device
El aparato
lost contact with your skin for 25 hours.
Pues no.
Not only
I don't know why.
did it lose
No
contact, but during that duration,
Ese
they also
también
tested alcohol.
resultó en detectó alcohol.
No he tomado alcohol, no sé por qué dice que alcohol, no he tomado nada. Desde que él me dijo que no tomara, no he
Since you
tomado
told
nada.
me I haven't, since
No
you told me
tomo
not to,
nada.
I haven't drank anything. I don't know why.
You got?
¿Qué tiene usted?
Well, Judge,
Bueno, es
I mean, this is my client's word
la palabra de mi cliente
versus
en
technology.
cuanto a la tecnología.
Being that it's an imperfect world, I
Es un
would
mundo
request the
imperfecto
court
de pedir
admonish
que la
him
corte lo
and
amoneste
make sure he gets
y
the
que se
problem fixed.
asegure de que entienda.
Sorry, Mr. Lazo. You tampered with the device for 25 hours. What am I supposed to do? Let you go?
¿Qué es lo que debería hacer? ¿Dejarlo ir?
No sé por qué, digo que siempre lo traigo igual, lo traigo donde
I don't
mismo.
know.
Y
I have
anda la
it
piel
the same
ahí.
every time. That's my skin.
Sí.
Judge, this is a second
Pues este
DWI,
es un
close to
segundo
2-car
caso
accident,
de
NHL, zero
con su
tolerance.
Yeah.
accidente. Pienso
I
que
agree.
debería ser otro
Taking you in.
Sí.
I'm sorry.
Entrar, lo siento.
The bond is set now at,
Entonces le ponemos entonces ahora
it's at $100. I'll set it at 5,001.
5,001.
Mr. Lazo, I need you to understand that we mean business. You can't tamper with the device for 25 hours. And they detect alcohol and think that good things are going to happen.
Si no hace eso, buenas cosas hubieran sucedido.
No alcohol, nada, nunca. Y esto
Nothing,
siempre anda
no
igual.
alcohol. It's always the
No lo he
same.
movido.
The device tells me differently.
El aparato me está informando.
Goes with you.
Yo respeto.
I respect the things that you told me.
We'll talk. Mr. Thurman, you're back. Okay. So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction that where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime, there's such a thing as lifetime probation.
There is.
Yes.
Whoa.
So that case, well, I'll let you do the talking.
No, he did his time and he got out and lifetime probation out of Michigan. So that's what's happened. I believe it got.
So how on what would, aside from like a murder case,
So he was
what
charged
would
with
garner?
murder twice, along with 2 armed robberies.
I wasn't charged twice for no murder.
It just shows up.
It just shows up
Oh, I was about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, him threatening to murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA, but I don't have the documents, which is why I can't present them. If there's an ICA hold, he's ineligible for a bond, because that's an ICA hold. I don't have it, which is why I can't say, but if I get the documents.
Interstate compact agreement.
I understand. May I speak, Your Honor? Okay. After we talking about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information and why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though.
I understand.
That's why he overlooked. He said, okay, it's fine. So he said it was fine.
Quick question, is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've not
this month.
heard. Okay, and then so there's not been a hearing on that yet, right?
No, but that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up, guys. I took the plea deal.
What are you on probation for?
The armed robbery conspiracy coming armed robbery. I did 5.5 years. Came home off lifetime probation. And to continue what I'm saying, I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday. I still showed up to court and got locked up. So there's no flight risk in this whatsoever if I've been showing up every single time.
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, and they give you a curfew.
Yes.
And you don't abide by the curfew.
I was working, Your Honor. That's why the judge has extended, because they had my probation curfew time I forgot what time they had as, but I had started my new job because I came, got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge, and he extended my curfew. He was like, okay, you've been working. I said, yes, I have documentation of new work. So I'll show all my documentation, and he said, okay. So the stuff he's mentioning violations for, they already been taken care of. So he's not stating that either. He said 2023 is, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. Obviously, I came with legit paperwork.
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge, and that's why he's not been revoked. So he's still here. As to the underlying charge, It's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was gonna get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus, that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taking care of what he needs to take care of, and he will still be here he's been on bond on the underlying case for about a year. Your Honor, he's not been locked up this whole time up until this recent arrest. So, and at this point in time, this is really just for since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Okay. Texas Code of Criminal Procedure 17.03. NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy, 2021. Probation transferred to Texas 3/20/21. Concurrently charged with murder, which was dismissed. No holds. Defendant is not indigent and defendant is alleged to have gone to complaining witness's home and pointed a gun at complaining witness and complaining witness's 3 children because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife. That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, you know that you're supposed to be out there with a halo over your head. And yet you pick up an aggravated assault with a deadly weapon where allegedly a gun is pointed at kids. I mean, the way your mannerisms.
I would say something, Your Honor, that's why.
But don't, though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man. And you got to understand that I don't know if you're guilty of this offense or not, but the problem is bad stuff keeps happening to you for some reason. It's like somehow, sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. Mr. Thurman, you scare me, man.
Yeah, I scare you, Your Honor?
Yeah.
And I've been out for a whole year since this case happened, and this is my first time being into this courtroom again, and you're fearful for whose safety if I've been doing nothing but right and working.
That's not true.
That has been true. I've been out for a year on bond and have not been into this no courtroom, but Orange Jumpsuit, I should say. Your courtroom, anybody's courtroom.
You want me to reward you for being
saying, but you say you're in fear. You say you're in fear for safety. That's what I'm saying. Like, who are you in fear of? I have not been into any trouble whatsoever. I've been squeaky clean. Just I bonded out.
And Your Honor,
you don't get rewarded for being a good person out there. You know what I mean? You're supposed to be like that anyway.
I understand that wholeheartedly, Your Honor. I'm just saying, but you say you fear, and I'm saying, how are you in fear if I've not been doing anything? That's showing you. That should show you some type of sign. Like, okay, he's not been doing anything wrong. So where is the fear come to play? That's what I'm asking you.
The fear is really because, when people come here, it's little bunnies jumping in the woods, rainbows, gumdrops. And then when they get out there, they turn into different people. It's like Jekyll and Hyde. And I don't want that. Like, I don't want someone out there to suffer because we let you out. I let you bond out. You've got an armed robbery, you've got an ag assault. You continue to violate conditions on those bond, right? That shows me that you're not willing to abide by bond. I mean, quite frankly, you're lucky to even be out on those charges with the ankle monitor, and you continue to violate.
Your Honor, you keep saying violate. Like, if I was in violations they have on file, by the way. those have been taken care of. Once again, you keep on saying violations, but they took care of. The felony court judge seeing I have proven, what's the word I'm looking for? Just proven, facts that this is why I'm late. I have a new job. I got fired because I got arrested from the other job. So I started a new job. For me having a felony in my position, and just call it what it is, a young Black man with a felony, it's hard for me to get a job anywhere. So the jobs I do get, I take up on those. So it's hard. Any shift they open up for me, I'm going to take it and show my work ethic to them. So I let the judge know that. He sees that. He understands, like, okay, that's why you keep on bringing up violations. I have to work. I have to eat. I have to have a house to live in, like anybody else here. So you keep on bringing that up. I'll keep saying, I already talked to the judge about it. He granted it already. He let it go. That's why I'm still free to this day. Well, was free to this day. And you keep bringing that up. You saying threat to your fear, which is understandable. Everybody gonna have fear, but I have not been into any trouble. I've been working. I've been working for a whole year. I've been on my P's and Q's. And like you say, the police report that you're reading, sir, the case is still open, so I can't really speak on it. I'm pretty say much, but it's a lot more to than what you're just reading on that police report. It's always gonna be video cameras and house ring cameras, body footage. It's gonna be a lot more other things that you're not gonna be able to read off a police report, which is understandable.
Just too much blood, Mr. Thurman. I'm sorry. I can't set you on. It's just too much. I'm sorry. Hey, this isn't.
Do not walk away.
This isn't.
I said, okay, it's fine.
Really, I understand that you're hurt, Mr. Thurman, but look.
I've been doing my best, Sean. And y'all sit here telling me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble. And you're a threat, and I'm a threat to society. Really? For a whole year I've been out, and they just not issue a warrant for me just now recently, and I come to turn myself in, and I'm a threat to society. And people, you fear me for what? From turning myself.
When it comes to monitoring devices like Scram ankle bracelets, courts operate under near zero tolerance. These devices are designed to maintain constant skin contact. If contact is lost for 25 hours and alcohol is detected during that same window, judges see that as intentional circumvention, not technical malfunction. The defense tried to frame this as client's word versus technology. But in the courtroom, technology logs often carry more weight than verbal denials, especially in repeat DWI situations. And notice how quickly bond jumped from minimal to $5,000. That's leverage. That's consequence. This isn't about punishment. It's about compliance enforcement. If monitoring conditions are ignored, courts escalate immediately. So ask yourself, if a device shows 25 hours of no contact plus alcohol detection, would you believe the defendant or the data?
And show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But y'all a threat. You can let go of me, sir.
Stop.
You can let go of me.
You don't not tell me how to do my job.
You can let go of me. Grab my arm too tight.
Guys, relax. Relax.
I'm too tight. All I said, grab me. Look how you grabbing me up.
Back up.
Look how they grabbed me. I said you let me go a little bit.
You gotta calm down.
I'm calm. I just asked him a question. I asked him why she let me go a little bit, sir. That's all I said.
Open the door.
All I said. What do you make somebody cuss you out or anything? You said I'm all tight. You listen up.
So he already waived, so if he
did.
holds it, then it
Just, yeah, I can't.
I'll go talk to him, but once again, Judge, understandably, I think I know that he's frustrated. I believe.
I understand. I get it. And I would be too, but I can't. That's just too much blood. It's too much.
It looked like there was
Even, what I'm going to tell you, even if he didn't have those bond violations, I'd still be very hard pressed to even,
No, and I was curious because when you brought it up, it was a little bit older, and so I was wondering why.
Do you know, are they going to come get him?
Oh, no, they're gonna get him. I was trying to figure out why now, and they were just having back and forth.
But here's the problem. So he hasn't made bond on those cases. So we're sitting anyways.
Yeah.
He has not?
No.
He said he did.
No, he's not made bond on those cases. He's
been in jail for a year?
No.
He may have, but they revoked the bond.
Ah.
Yes.
So he's sitting there, and I didn't have the heart to tell him right now that the 14 days is not going to apply.
Yeah.
Because
So I gotta do that.
I will. I really.
I will. I'll let him know.
I'd imagine it's gonna get resolved because it's one of those. It's a bizarre. So we revoked. Harris County revoked because Michigan revoked because it was charged with the ag assault. So it's a chain of events because the only thing the court sees is that they revoked
So-
on the probation, which is caused.
Please let him know that the days hasn't kicked in and it will not.
It will not kick in.
Resolves.
Right.
And either he resolves the cases.
So which one does he need to resolve first in order for?
Well, for the felon possession of weapon, there's, hold on, I want to see.
Is there an offer?
No, it's going to trial. That's why it's been reset out. It's been set for jury trial at least.
Four times.
4 times. 1,
Yeah.
2, 3, 4, 5. Yeah.
5 times, Judge.
Next time is January 6th, 2025. But he's held on 55,000 bond for the assault and 55,000 for the felon possession. So he has to come up with 110,000 for.
Wait a second. So
it doesn't matter what you did today.
can't, even if I gave him a bond today, he would still have to make those bonds.
110,000.
So my question now is, when did that warrant for the felonies pick? Because he's saying he's been out for a year ever since this
I'll
ag
explain
assault got picked up.
I show a remand defendant custody on November 18th, but I don't know what the previous.
So the only reason why his felony bonds got revoked was because Michigan revoked.
Oh, no, it doesn't, but we don't know that for sure.
Yeah.
Because there's no notes that reflect why they revoked the bond. It just says court directive remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay.
It's remand to custody, violation report, but that's not a revocation. Yeah, because.
It's a violation report from Michigan?
No, for me. So remember when I said the newest violation was on November 1st for all the curfew violations?
Mm-hmm. Is that from here?
Technically, that could be the reason why they revoked instead of Michigan. I don't know, because I don't have the document.
Yes.
So.
But he hasn't gone out to Michigan to I guess take care of
For that
the
one,
current bound violation.
2023, so it would have predated.
I get you.
Take some time for them to do it, which is why I hate it, because they should have waited to file it. But whomever originally had him, well, actually, if he said he was in the courtroom, that happened. Yeah, sheriff's office. So they should have known to wait to file.
I got you. Okay.
Okay, well, I guess reset to track locals. Oh, man.
Don't set it to January.
I'm not. When in December would you like to touch base?
Now, my question now is, does it matter for us to touch base if his locals are gonna be reset far out? What's the point of?
Yeah, we have to,
If they
you gotta
do
keep
like
it.
a plea deal.
Makes sense.
Or mid-trial dismissal, because it's Troy Locklear on the one.
So let's do this. Do you see a date for like a pretrial motion or a pretrial setting for them?
Trying to file a motion.
Highly doubt it, Judge.
I mean, there's nothing between here and there. Judge Jones, I would be surprised if they set another.
Okay.
So if you want to talk to Troy.
18th, 17th of December?
17th of December.
Finner?
Yeah.
Is it Troy Finner?
No.
Troy Locklear. So hold on, December 17th.
I'll find out.
Yeah,
All right.
okay.
17th or 18th, whichever one of those days works for you, I'm good by it.
I live in this building, you tell me.
And then if you have any problems with him, we can bring him back out as far as just tracking locals, meaning that just let him know they revoked the bond. And essentially the time here is kind of told until he either gets a bond reinstated, post bond, or somehow deals with the case.
Because the bond is set, so if he can come up with the money, he can. But I'll put 17, and then if you want it sooner or a couple
Got
days
you.
out, let me know.
Sounds
See you
good.
tomorrow for.
Yes, sir.
Okay.
I think
Thank you, Judge.
we are done.
Maybe excuse Judge.
Oh my God.
Blake Jenkins. Mr. Jenkins, you're charged with 2 cases. You're charged with 2 counts of terroristic threat. Was he on bond for this case and then he picked up a new case?
Yes, Your Honor, it appears so, that he was on bond for the.
He was literally on bond and then a week later he picks up a new case.
Can I say something?
Don't. Are you here with anyone today?
Sure.
Yes, it appears correct. He was on bond and then he picked up a new case.
So as what I see, he picks up his first terroristic threat. We gave him a PR bond on November. So tell me if I'm wrong. So check this out. Tell me if I'm wrong, but it looks like both of these were just both 2Bs, meaning warrants had been issued, and he had not been picked up. This is Jenkins. And it looks like we picked him up all at one time, and he was given a PR bond on November 13th.
On the terroristic threat?
On both cases, they're both terroristic threats.
Yeah. Yeah, because it would have taken a month for him to get arraigned. So it must take.
Yes, Your Honor, that's correct. There were.
Okay, so he was not on.
No, he was not. There were both 2Bs, Your Honor.
Now, do you guys know the relationship of Ryan Kalal?
He was just a member at the gym that the defendant attends.
Okay, so let's just go ahead and do probable cause on both cases.
Okay.
So Mr. Jenkins, you're charged with 2 cases. You're charged with 2 counts of terroristic threat. One is against a family member. So on that one, you're facing up to a year in jail and or a $4,000 fine. Your other case is just against a garden variety civilian. So on that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
So for the terroristic threat involving a family member, the complainant and the defendant are brothers. The officer was dispatched to a residence in Harris County, Texas, in response to a family disturbance. The defendant was removing the complainant's belongings from the residence and putting them in the back of his own vehicle to prevent the complainant from getting his things. The complainant tried to remove his things from the back of the vehicle when the defendant stated, "I will kill you." The complainant was in fear for his life when the defendant said this. The defendant also later texted the complainant that if he touched his things again, that he would cause him severe pain. And then for the other terroristic threat on October 26, 2024, the officer was dispatched to Crunch Fitness in regard to a terroristic threat. The officer made contact with the complainant. The complainant, the manager at the gym, stated the defendant was involved in verbal and physical altercations with other members, and multiple complaints were filed. The complainant stated that the defendant's membership was canceled due to the issue with other members and the defendant making threats. The defendant then continued acting aggressively after finding out this information and caused a disturbance by screaming and cursing loudly. The complainant told the defendant he needed to leave and not return. The defendant became more agitated, left the business, but returned multiple times. The complainant stepped out with the defendant and told the defendant repeatedly not to return. The defendant responded multiple times he was going to come back to the business and kill the complainant.
All right. So Mr. Jenkins, I'm going to find that there's probable cause to go forward on both of your cases. I'm now ordering you on both of your cases not to have contact with each of those witnesses and not to go where they either live or where they work. Do you understand? In the first case against your brother, a protective order has been issued. So I would get to know that protective order, because if you violate the protective order, they will file additional charges against you. You violate those conditions, I can hold you at no bond, 0 bond until this case is over with. And I want you to know that I will protect every single person of Harris County by all means necessary. And if that means putting you in jail, locking you up at a $100,000 bond, $50,000 bond, 2,000, whatever it may be, it's going to happen. Do you understand?
Yes, sir.
I'm also ordering you not to be in possession of any weapons as well. You're not to go back to Crunch Fitnesses also. Do you understand?
Yes, sir.
You pick up any known cases, violate even 1 iota of these conditions, I'm going to keep you with me. And I'm going to tell you now, it's going to be high. And if you don't have anyone to pony up that kind of money, $10,000 to get you out, you will be stuck like Chuck in custody until these cases are over with. And I'm going to tell you, it takes damn near 9 months just to get a 911 tape. Do you understand? How old are you? What do you do for a living?
I worked in catering, and then now I'm doing solar. So I'm a sales representative.
What kind of money you make a month?
I haven't made any money. Right now I'm living off unemployment checks because the money I had from my last job ran out, and the money that I'm making on my new job is all commission. So I have to close the deal before I have any income.
Who are you living with?
I'm actually living in my car at the moment.
Okay. I'll have you fill out an application for an appointment. Actually, let me see your name. On this application, you says your spouse's salary is $10,000 a month. What does that mean?
My what?
It says under spouse's salary, $10,000. You make a total income of around $11,000 a month.
Did I fill that out? I didn't fill that out.
I'll have you fill out a new one then.
Okay.
So you're living in your car.
Yes.
How is that?
I mean, it's fine as long as it's not too high.
Sucks. Sucks to live in your car, doesn't it?
I mean, I don't have any money, so I mean, it's better than the street.
What I'm trying to tell you is that when you're living in someone's house, under their roof, don't bite the hand that feeds you, because register what I'm trying to tell you, Mr. Jenkins. If you're under someone else's roof and they're kind enough to take you in, when you bite the hand that feeds you or burn a bridge, you never know when you may need to cross that bridge. Now you've burnt a bridge, you can't even cross that bridge. You're living in a car. Living in a car sucks. So be nice. It's not hard, especially when you're living under someone else's roof. It's not that hard. And if you get into an issue where you fight with someone or you're upset, walk away, find another release. Do you understand what I mean? It's not hard. Be nice. Do you mind giving an application? I'm gonna have you fill out this application because I need to know everything about you as far as money-wise. I'm gonna have you sign a reset with Jermaine, and then I'm gonna have you take a seat in the jury box while we get all your orders ready and while I find you a lawyer, okay? Okay.
So I'll be on the court today?
Yeah, I'm gonna have you talk to a lawyer today.
This final exchange shows the heart of bond law. It's not about guilt, it's about risk. The judge repeatedly emphasizes public safety, prior armed robbery convictions, lifetime probation, curfew violations, GPS monitoring issues, and a pending aggravated assault involving a firearm and children. Even though the defendant argues he turned himself in, which courts do consider, the pattern of violations outweighs that goodwill in the judge's eyes. And here's the legal reality. When someone is already sitting on high bonds totaling over $100,000, today's decision almost becomes symbolic. The system layers consequences. What makes this moment powerful is the emotion. The defendant feels unheard. The court feels cautious. And somewhere in the middle is the law. Ultimately, this session shows how judges weigh compliance, history, and credibility far more heavily than promises. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.